Hello everyone, my name is Shivangi Tiwari and I am from Hidayatullah National Law University. Today in this video, I'll be dealing with offer of performance, and the topics which I shall be covering are the obligation of the parties to perform, tender of performance, by whom the contracts must be performed, effect of accepting the performance by the third party, and then lastly I'll be dealing with joint promises and devolution of joint liabilities. So the term offer has been defined under section 2A of the Indian Contract Act. An offer is an expression of willingness made by a person to do or abstain from doing an act or omission with a view to obtain the assent of the other person to whom such an offer is made to such an act or abstinence. The term performance in its literal sense means the performance of a task or action. In its legal sense, performance means the fulfillment or the completion of obligations which one party had towards the other party by the virtue of the contract which was entered between the two parties. Section 37 of the Contract Act talks about performance. According to this section, there are two types of performance, which are actual performance and the attempted performance. Attempted performance is also known as tender. The next topic which we shall be dealing with is the obligation of parties to perform. So, the obligations in a contract are those duties which the parties to the contract have to abide by. In a contract, the parties to the contract usually exchange something which is of value in the eyes of law. The thing which is decided to exchange can be any product, service, money, etc. So, an example of contract of obligation is with the sale of products such as an automobile, where one party has the obligation to transfer the ownership of car while the other has the obligation to pay for such a transfer. Now, what is a tender of performance? So, Article 37 to Article 39 of the Indian Contract Act specifically deals with the performance of contract by parties. So, according to Article 37 of the Contract Act, the parties to a contract are under the obligation to perform, either perform or offer to perform the promises to offeree which have been agreed upon under the contract. The offer which is made is called the tender of performance. It is the discretion of the promisee to accept the offer. So in a case where the promisee chooses not to accept the offer, then neither the offerer could be held liable for non-performance of the terms of contract, nor he loses his right under the terms of the contract. Now, Section 38 of the Contract Act makes it clear that a tender of performance tantamounts to performance. So, every tender of performance must fulfill certain essentials which are mentioned under the same section. So, under subclause 1 of under subsection 1 of section 38, the offer should be unconditional. Then section 38 subsection 2 states that the offer must be made at proper time and place, which allows the party to have a reasonable time for ascertaining that the person who is making the offer to him is competent enough to enter into a contract. Similarly, subsection 3 of section 38 of the Act mandates that if the offer to the offeree is such as to deliver some good addressed to offeree, then it is the duty of the offerer to provide reasonable time to the offeree in which he can ascertain that the goods offered by him is the same by which the offerer is bound under the terms of the contract. Now the next topic is by whom the contracts must be performed. So Section 40 of the Indian Contract Act contains provisions regarding the performance of the contract. This section provides that if by the terms of contract it is evident that the intention of the parties to the contract was such that any promise contained in it must essentially be performed by the promiser himself, and no other person on his behalf can perform his promise. Now, what is the effect of accepting the performance by any other third party? So, Section 41 of the Contract Act contains provisions regarding the effect of the acceptance of performance of promise by the third party. The section provides that where the promisee agrees to the performance of a promise which is made to him by the offerer by any other third party, he cannot at a later point of time enforce the same contract against the promiser who was initially bound by the promise. Now, if the terms of the contract indicates that from the very beginning the parties which enter to the contract had intended the specific performance of the promiser by the promise by the promiser himself, then no third party could ever be accepted to perform the promise which was upon the promiser to perform. Now, the last topic of our discussion is joint promises. So, Section 42 of the Indian Contract Act talks about joint promises. When two or more promisers agree to perform the terms of the promise together, they are said to have made a joint promise, and the person who jointly agree to perform the promise are called the joint promisers. This section also provides that the promisers are jointly liable to fulfill the promise until the terms of the contract provides anything contrary to this provision. Now, devolution of joint liabilities is also dealt under Section 42 of the Indian Contract Act. According to this section, in cases where several joint promisers are involved in the contract and they make a promise jointly, then during the joint lives of all these promisers, they must fulfill the promise jointly. In case of death of any of the promisers, the representatives of the deceased promisers along with the surviving promisers should strive to fulfill the promise which was made to the promisee. Now, that was all for today's video. I hope you find this video helpful. Thank you.